Okay. And moving on, we're going to talk about what is a trademark. Okay? And here we go is the definition again. Word, phrase, symbol, or design identifies and distinguishes source of goods, one party from those of others. Okay? Simple, several parts to it, but it is pretty straightforward. Just what's the difference between, say, Exxon and Mobil, right? Each one is a word. Each one distinguishes one manufacturer of gasoline from another. Okay? Here's some examples. Wendy's, I don't know why I'm on a food thing recently here, so you're going to see some examples of food. And you can see that there are actually a couple of marks there. You see Wendy's, you see that there's a little circle R next to it. And you also see Old Fashioned Hamburgers has a mark next, a circle R next to it. Those are words, right? And each one of those has a federal trademark associated with it. Here's where it gets a little complicated. Babies. I know you appreciate this because you're probably dealing with a number of these products now with twin little boys. And you can see from each one of these manufacturers, they all use babies in their image, right? So how are they distinguishing themselves one from another? Well, it's in the wording. Like say green baby versus evergreen, right? As you see the top two images there. And then back to food. Here's a symbol, pretty famous one, right? KFC. Okay. So we've talked about trademarks. I don't know, has anyone ever heard of service marks as well? No? Okay, great. A service mark is pretty similar to a trademark. The difference is that we're not talking about the source of goods, but we're now talking about the source of services. Okay? But now, people make that distinction and stuff like that, but we're just going to use trademark throughout to cover both. But I wanted to make sure that you're aware of that because a lot of businesses have both trademarks, their source of goods, as well as service marks, source of services. Girl Scout is probably a pretty good example. Immediately in your mind you might think of the cookies, right? That's good. But really the mark is for a service. It's for empowering and educating young women, okay? So really they're classified as a service mark and not as a trademark. In terms of rights between trademark and service mark, there's no difference. So how many people here think that this is a trademark? Is anyone going to raise their hand and take a guess? No? No. I saw some people shaking their heads, so they got it right. All right? It's a shopping cart. It's not a trademark. All right. How about this one?
Absolutely.
Okay. That's interesting. Everyone else? Anyone else want to wager? This one is a little tricky. I'll give you that. Now, definitely Purdue is a trademark. But, as remember we go back to the definition, we're using a word, phrase, things of that nature to identify and distinguish the source of a good of one party from others. Purdue is not a trademark for dog bowls. Okay? It is for educational services. So you can go either way there.
But would they be able to use it without Purdue's information or Purdue's approval?
Right, most definitely. This is called a secondary use, right? So they would definitely need to have Purdue's permission because they are marketing and they're using the mark in commerce, selling the bowls. Okay? All right, who thinks this is a trademark? All right, great. Excellent. I think everyone's going to get that one right.
There's an R there.
You see the R, yes. Perfect. And that's exactly what I said. You see the R, so you're right on point. And you see here you have the mark as well as the good, the coffee, right? And you see they're changing their mark. Just want to keep you informed what's going on. World of trademarks these days. All right, so moving on. Okay, we talked about trademarks. How do you get one? Okay? Now these are a number of different reasons why you should get one. And what I've done is I've underlined some of the more relevant, right, or most important, based upon the work that I've had for my clients. These are the most important reasons for getting a trademark, a federal trademark registration. Please note, though, that you do not need to do a federal trademark registration in order to have a trademark. All you have to do is take that mark and put it into service, right, in some form of commerce. All right? So back to our definition, there wasn't anything in there where you have to file a document with the patent attorney or with the patent and trademark office or something like that in order to have a trademark. But in order to have a federal trademark registration, you do have to go through this process. Okay?
When do you have your rights? Only when you go through the trademark registration?
Okay, when do you have your rights? You have rights immediately as soon as you start using a mark in commerce, but they're common law rights, okay? You don't have real rights to take someone to court until you've done the federal trademark registration, okay? And that was one of the basis. Sorry, I went through that pretty quickly. And that's a good point for me to bring up with all of you, that if you want a copy of this presentation, just email me and I'm more than willing to send it out to you. So here are some of the steps, major steps, of a federal trademark registration process, right? You have your pre-filing considerations. Are you going to use an attorney? Are you going to do some sort of mark selection, right? Are you using your mark in commerce already? These are the things that you need to know before you make the decision to go through with filing. Are you going to do some sort of search? I forgot that one. It's complicated. Going through and doing the federal trademark registration is not easy, okay? And there are things that you do now that will have an effect upon your registration later. And if you're not aware of those things, it just could be a waste of your time and your effort. So it's definitely my suggestion to hire an intellectual property attorney. These are some of the reasons why, right? These are the things that an intellectual property attorney can help you with. So I didn't go through the rest of these things. So federal trademark application. The basis of filing for a federal trademark registration is based upon you filing an application first. You take all the information that you have about your mark and you file it with the United States Patent and Trademark Office. After a period of time, they will assign an examiner. The examiner reviews your application and comes up with reasons why you shouldn't get your federal trademark registration. Typically, they're easy to address. They actually give you suggestions on how to overcome the rejection. And once you've done all of that, then your mark is published for opposition. Publication is a 30-day period of time where anyone who has any sort of issue can oppose your mark, okay? After you pass that 30 days or after you've resolved any sort of opposition issues, your mark will go for registration. And after you've had your registration, you get your registration, you just have to keep your registration current through maintenance. Okay, so that's just a very basic walkthrough of the steps for getting a federal trademark registration. All right, so I talked a little bit about hiring an intellectual property attorney. Mark selection. This is one of the steps that you have to consider. Strength of the mark is very important. I don't know how familiar you are with this, but you have everything from fanciful, which is given the highest level of trademark protection, to generic, which you actually can receive no level of protection, okay? And it just works from strongest to weakest, top of the page to the bottom, all right? Some of the things to consider: if you are in the descriptive range, you do have to show some level of effort, time and effort that you've put into the mark in order to get registration sometimes. While if you're on the fanciful range, you're definitely going to spend time and energy trying to inform your public, the consumers, how that mark is tied to you versus your competitor. Because it's just a fanciful word. If I just came here and said, right? I mean, what is that for? What does that do? You have to inform them of what it does, and you have to get them up to speed. So there are advantages and disadvantages to being anywhere on that scale, except for generic. There's no advantage being generic. So you had mentioned the circle R, right? That's the symbol to show that you have a federal trademark registration. You will also see TM and SM sometimes. That could be based upon a state registration or just because people are using it in commerce, okay? But when you have your trademark registration, you should use it in an appropriate fashion. And these are some of the best usage terms, or best ways to use your trademark appropriately. I wanted to give you some examples so we could talk through, say, mark selection. This is a couple of registrations I did for my clients last year. You see, Axis Imaging is a medical imaging company specifically dealing with X-ray. And as you can tell, you can kind of almost get that idea out of their mark, right? You see the symbol of the X, and you almost see the X-rays crossing there. And it kind of gives you a sense as to what they do, okay? While on the flip side, here you have Heritage Environmental Services. This is another trademark registration I did for one of my clients. And here they're an environmental services company. They take waste product from one company and they either process it or they just hand it off to another company as, you know, one of their reagents or something. And you can see that. You don't really get all of that by just their mark, but as you see the circle of arrows, you might get that sense. Like as soon as someone says to you that this is an environmental services company, boom, you start seeing the arrows and you see the reuse of material. It leads you to that interpretation. Okay?